Hello, my name is Lawrence Atkinson and I'm briefly going to take you through a short presentation I gave to the City of Sydney Law Society recently on improving profitability through credit management. All credit management starts with the cost agreement, and you need to ask, does your cost agreement or your retainer comply? Comply with what, I hear you ask? The Legal Professions Act of 2004. You will find details from the New South Wales Law Society on what your agreement needs to look like and what you need to have within that letter of engagement. You would also need to be aware of who the parties to the agreement might be. Sometimes, many occasions, the person paying the bill may not necessarily be the person involved in the matter. However, they do need to be included in the cost agreement. And if you're using a precedent for your cost agreement, when was the last time it was reviewed? I've seen retainers referring to the Legal Professions Act of 1987, and here we are in 2012. Not a good way to start a relationship with a client. And what about taking money up front? How much should you take into your trust account? Why wouldn't you do that? Do you need to undertake a risk assessment? Yes, I suggest you do. And what's the difference between trust money, controlled money and transit money? And what's the difference between trust money, controlled money and transit money? Don't know? Then you need to check it out, particularly controlled money. And billing. Do you have a regular billing cycle? Certainly matters may go for a longer period of time, but you need to ensure that you bill regularly. You send them interim bills, keep up to date with obtaining those payments. And are you a lawyer or a banker? I've seen so many lawyers who end up providing credit through the length of debtors that they have. Some simple rules to obey. 60% of your debtors should be current. Your relationship with your client starts and ends with you. Don't rely on your account staff to chase payment unless they're really, really good. You need to be working on your business as well as in it. That means you need to chase your debts. Understand what your financial drivers are, the size of your work in progress, and what your debtors are. And what about the average days? Average WIP days should not be more than about 30. Average WIP days is the number of days it takes you to do the work before you even bill it. In this example, if it's 51 days before you bill, and then another 64 days as showing here, that's 115 days that you're working on something before you even look at getting paid, and that's providing you do get paid. Can your business afford nearly 4 months of not being paid for the work that you are doing? Don't be a credit provider, be a lawyer. So, if you need help, there are some ways that you can do that by putting some good credit management rules in place, enforcing those rules and taking responsibility for doing that. It is your firm. If you need help, please give me a call. 0407 236394 is my number, or you can get me at lawrence@lawrenceatkinson.com. Thanks for watching. Bye for now.